Hi, my name is Robert Chelle with Chelle Law, and I'm an attorney that assists nurse practitioners with employment contract and independent contractor agreement issues. Today I'm going to talk about nurse practitioner contract red flags. So what are some of the most kind of hot button areas that you need to be concerned about when you're about to sign a contract? First would be compensation ambiguity. It's let's say the most common compensation model for a nurse practitioner is just a straight base salary, which is very easy. There's no kind of concerns with that. But when you get into kind of hybrid models where you're paid maybe a smaller guaranteed amount and you have some productivity incentives involved, if you're working for a hospital, it might be RVU based, whereas if you're in private practice, it's not going to be RVU based. It'll be more percentage of collections that you receive. You want to make certain that if you have any kind of bonuses, that it says specifically when it's paid out, and then secondarily, if you earn the bonus, it will be paid out to you regardless of whether you're employed at the time that it's paid out normally. And let me give you some examples. So let's say there's no language about when a bonus is paid out. Maybe you give notice in November, then you work out 60 days. You've earned the bonus by the end of the year, but it doesn't say when they have to pay it to you. And then there's a clause that says if you're no longer employed, you get no more compensation. And what they'll do is either just sit on having to pay the bonus and won't pay it out until you've seen your last patient, your termination date, and then you won't get the bonus. So make certain it says when it's specifically paid out, and then once you know that, also, if you've earned the bonus, it will be paid regardless of whether you're employed at the time. I mean, employers can get sneaky with trying to withhold payment and messing with your termination date. And sometimes if there's not clear language about, how the employment relationship is handled after you've given notice, sometimes they'll accelerate the date of termination if there's like a bonus deadline looming, just to get out of having to pay the bonus. So that's one thing you need to be certain is very clear in the contract. Next would be non-compete issues. So it's very likely you're going to have to sign a non-compete. There's a handful of states where they're unenforceable, but for the most part, in most states, they are enforceable as long as they're reasonable. Now that reasonableness standard does change from state to state, but you want to make certain that you're not going to be completely out of luck when the contract terminates. And so a few things to make certain are in your contract. There's three components to any non-compete: the scope, meaning what you can't do, the time, how long the non-compete lasts, and then what's the geographic restriction. So for an NP, it's very important that the scope is just what you're doing for that employer. So if you are working in orthopedics, you want it to say you can't work as a nurse practitioner in orthopedics for 1 year and 10 miles or something like that. If you're working in nephrology, it needs to say you can't work as a nurse practitioner in nephrology. An NP can do a lot of different things. And so you don't want to completely be cut off. So you cannot accept language that says you can't practice as a nurse practitioner, full stop, for 1 year and 10 miles. There's no rational argument that can be made if you're working in primary care or even pediatrics or something, and then you switch over to a IM subspecialty or something like that, where there's absolutely no competition between the two. It's completely unreasonable to say that the nurse practitioner can't work at all. So making sure the scope is limited to your specific employer, and that way you have options. You can do primary care, urgent care, hospitalist work, ED work, any other of the subspecialties, just so you don't have to move or worry about the restrictive covenant after the contract terminates. Malpractice. So if you have a claims made policy, who has to pay for tail insurance? It's not prohibitively expensive for a nurse practitioner, but a good rule of thumb is tail insurance is about twice what your annual premium is. Most NPs are somewhere between $1,500 to $2,000 per year. So you would double that, and that would be your tail cost. But Ideally, the employer would pay for your tail. So that's one thing you definitely need to think about. Termination imbalances. So there always will be some kind of without cause termination notice. Most of the time, 60 to 90 days in healthcare. But what you don't want is like the employer to only have to give you 30 and you have to give them 120. That's not fair. It should be the same for both parties. And then also, there will always be language in a contract about if the contract is terminated and maybe you have some they paid you some bonuses to come over or start, or some relocation assistance, that if you leave within a certain period of time, you may have to pay back some of those bonuses to make certain that those are favorable to you as well. I mean, there's dozens of areas that we could get into that could have red flags, but those are probably the biggest ones. If you have any questions about your employment agreement or independent contractor agreement, feel free to contact my law firm at the information listed below in the description. And I appreciate you watching the video. All right, thanks. Take care.